Good evening. This is John Milburn for Laws 11057, Introduction to Law. We're into week 9 of term 2, 2017. We have a lot to cover. Tonight, to some degree, you are perfectly entitled to mark my assessment. The reason is that we're going to be talking about communication. And in the context of verbal oral communication, you'll be listening to the way in which I talk, the content of my discussions, and the bad things that I do. I say that because I understand that everyone has their bad habits. I certainly have mine, and I encourage you to let me know. You won't be penalised for doing so. I will encourage you to do so, and I will reward you for doing so. So on UCrew, there'll be a session which is entitled something to the effect, what does John do wrong in his verbal oral communications? And I will take that in good stead, and I will learn from that, because even though I've been practicing law since the early 80s, I'm always keen to learn. Never stop wanting to learn in terms of law or technique or procedures. So when you're doing that, ask yourself, what are your bad habits when it comes to oral communication? Do you use fillers? Do you use, is there a word limit, says Gay? Absolutely no word limit on that one. Do you use fillers? Do you unconsciously or consciously say or are or do something of that nature? Do you repeat yourself? So everyone has these things, and sometimes what it takes is for you to be filmed. So encourage someone in your family or friend to film you while you record some written material, while you present some oral material, and just play that back and critically ask yourself, how did you go? Your voice is very important. Now let's think about your voice as a practicing lawyer. In court, think about the tone of your voice. Think about the pace at which you're speaking, and think about your breathing. When you're before a magistrate or a judge, you're entitled to feel nervous, and it's good to be nervous. It means that you care about what you're doing and you care about your presentation, but be ready for it. And typically what most people do in front of a court is speak too quickly or mumble or both. How many times have you listened to a recorded message where someone has said, "Oh, please phone me back, and my number is blah, 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 blah," so quick that you can't catch it. And you have to listen to the recorded message 3 times in order to write the number down. Maybe that doesn't happen to you, but it certainly does happen to me. Part of the reason people do that is they know their number, they're familiar with it, and they'll just rattle it off. But remember, your aim as a lawyer is to communicate, and communication is all about imparting information from yourself to someone else. So look at communication from the perspective of the recipient rather than think about it from your perspective. In front of a court, they want you to do well, but the court wants to know who they're dealing with. So when you come to announce your appearance, for the record, my name is Milburn, Milburn, initials JA, counsel instructed by Smith & Co. You say your name slowly enough that the court can write the name down, spell it out so that the court can follow what it is, and then the court will look at you and say, okay, now I know who you are. They probably know me anyway, but now they know who you are, and that's a key point. Speak slowly, deliberately, clearly in that opening exchange with the court, and you will immediately gain some credibility that you need. Use your acting skills, both in terms of a court and dealing with clients or in a mediation session. For the last 3 years, and hopefully next year, I've had the privilege of taking alternative dispute resolution as a course in CQU, Laws 12062. And what I have done is have people engage in a mock mediation or conciliation session where they are filmed and they record the session. And I'm looking for those things because in a mediation session, in front of a client, in front of a court, you are always looking to persuade. So use your acting skills. It's not dishonest, it's not inappropriate, and you are entitled to have slightly different personas depending on what it is that you're doing. I have a different persona in court than I do when I'm teaching or when I'm speaking with my mates, after golf or family at home. They're all similar, they're very close, but there is a slight difference. And even in court proceedings, I have a difference between the way in which I present typically in a magistrate's court to the way in which I present in a district court. It's not meant to be that in any way I disrespect the magistrate's court, far from it. But I temper my presentation to what is required by the recipient. In a busy magistrate's court with 50 people behind me ready to take their turn, I'm not going to be as slow and deliberate as I would be in a district court or Supreme Court matter where I'm the only matter for the day. So you temper the speed, you think about what the recipient wants. Either way, when you're in court, the first few sentences are absolutely critical. You need to present so that the court understands who you are, who you represent, why you're here, and you can answer these critical questions. What do you want? And why do you say you should get it? They're critical questions, and be prepared to answer those in the first two sentences. What I want, Your Honour, is a sentence that does not involve a period of actual imprisonment. I say that because there are strong mitigating factors and there are certain issues that must be considered in this particular case. So be prepared for those first things. So to some degree, you're using acting skills. Physically, you present yourself as a lawyer, not just in court, but all the time now. I want you to think about doing this course as if you have finished the course, as if you are now lawyers and you are practicing. So physically, in court, for example, stand up straight, make appropriate space for yourself so that within the confines of a relatively narrow area, you can move around, that you can use your hands, that you can step back from the bar table if you need to, just a fraction, or step into the bar table. So own your little space around the area where you're talking. Announce your appearance, then wait for a moment before you start. Make sure that you maintain eye contact with the court. Have an excellent opening sentence and speak slowly. If the default position is speak slowly. So remember, of course, that in court, you are the storyteller. So to emphasize that need for some acting skills, you are the storyteller. The court is very interested in what you have to say. I want you to remember this. Some advice that my father gave to me before I went off to do my first public speech when I was, in year 6 or something. And he said, just remember, the audience genuinely wants you to do well. They look at you come in and they say, help me, I want you to do well. The court's the same. The court wants you to perform well. So don't be shy or scared or feel that you're not supposed to be there. While you are there, you're in play and your job is to help the court because primarily you are officers of the court and your primary duty is to the court when you're before it. So the court wants you to do well. When you make a point which is important, pause for a moment and remember to breathe. Exhale and inhale so that you've got enough breath to sustain you. Think about where you might hold your breath, where you might exhale. If you exhale, it gives the court a chance to relax just a little bit so that they can take in that last point. If you hold your breath all the time, the court's sort of holding its breath as well, and you don't want that. You want them to be able to say, okay, I get that point, you've made it well, and now you can move on slowly. To some degree, those same techniques are useful when you're interviewing clients or where you're representing a client in a mediation or some form of alternative dispute resolution, or you are a participant. So think about the object of legal communication. It is to impart something to the recipient. When you're interviewing a client, two critical questions. You need to have an understanding of what it is that you want, what the client wants. So firstly, the first question that you've got to ask yourself when you're interviewing a client is, what do you want? And the second is, what do you want me to do? If you can't answer those questions, then you really haven't elicited the proper information you need from the client. In order to elicit the proper information you need from a client, sometimes you just need to not talk. You need to listen very carefully, and your listening needs to be active listening. Sometimes that means don't jump in too early and say what's needed, but no more. Make sure the client is able to express something. However, you need to be, when interviewing a client, authoritative. You need to maintain control of the process. It's the same thing in court. It's the same thing in a mediation or other session. In court, it's a little different because, of course, you always submit to the jurisdiction of the court. And if the court asks you a question, you stop, you listen very carefully, and you answer that question. The court asks the question because they really want to know the answer. So don't avoid answering the question. You can put it off, but preferably don't do that. So when you're interviewing clients, you need to be comfortable, authoritative. You need to maintain eye contact. That's very important. You need to be very attentive, listen carefully. Obviously, you're respectful, but one of the ways in which you can gain the right information from the client, the information you need, is to clarify. And in ADR, we do a couple of things in terms of clarification. One is summarizing. So clients aren't necessarily good at conveying the information that you really do need to know in order to provide them with advice. One way to do that is to cut them off politely, but sometimes firmly, and say, all right, so what you're saying is that you have a dispute with a neighbour, you're concerned about the fence, and more particularly, you're concerned about the cost of the fence. Is that correct? So that's a summarising technique. The other related technique we use in clarifying is we call reframing. And that's where we detoxify the statements. So an example of a reframed sentence would be where someone says, you know, my co-worker is always untidy, always a slob, always late. You can detoxify that to a degree by saying, all right, so you have concerns about the co-worker and it's important to you that people all carry their weight around the workforce. Yes, right. So you're taking some of the emotion out of it, getting to the heart of the issues. When you're taking instructions from a client, can I ask you how you would deal with this basic dilemma? I've said you'd need to maintain eye contact, but you also need to cover yourself from a professional standpoint by taking good detailed notes. I'll say this. If there's a dispute and a client says, you didn't tell me that, or you didn't advise me to do this, and you say, yes, I did, in front of a tribunal or a court or an employer, they will always say, where are your notes? They'll never look to the client. They'll never say to the client, where are your notes? The obligation is on you as the lawyer to have maintained good notes. How do you do that? How do you maintain good notes and maintain eye contact at the same time? Any suggestions? Record the session.
Abbreviations and shorthand.
Yep, I agree with that, Sarah. Abbreviations and shorthand, yes. Who else had an idea? James?
Yeah, I was going to say sort of, I'll talk to the client, we'll have a chat, and then you sort of, have a bit of a pause, write down the notes, and then go back to it.
That's a good technique. Melissa says, after the appointment, do a detailed file note straight away. That's also a very good technique as well. Sunny said recording the session, you really can't do that. Sometimes you can selectively. You can't record other practitioners, and you can't record court proceedings. So there are a few things that you can do, but it's difficult. One thing I do is, I think I've mentioned in the past, I use voice recognition software. So I will, with the client's permission and with their knowledge, have my recording, my ability to record notes by typing them ready to go. And I have hotkeys, of course, and the mouse, so that when I'm doing the summarising, I will normally hit the go button so that as I'm speaking as my summary, I can actually see it being typed on the screen. Then when I've finished what I have to say, almost without the client realising, I hit the stop button so that I then move. The next time I summarise, I repeat the process. I actually do that in tribunals as well. So if you ever appear before me in a tribunal, you may see me at my computer and I'll be hitting the on-off button primarily when I speak, so that's picking up my voice, and it's a very good note for myself in terms of the procedure. Proceedings are always recorded as well, but I like to keep my own notes, and that's one way I do it. So bear in mind that you have the obligation to both engage with the client, maintain eye contact, listen carefully, but also record notes. So do what you can to do that, and some very good ideas there. All right, what else do we need to do in terms of good communication with the client? We need to have empathy. We need to tell the clients the truth, but we can't promise them things that which are not truthful. So if your client doesn't have a good case, you've got to be brave enough to say you don't have a good case. They may argue with you and say, yes, I do. You say, no, you don't. That's just part of your job to do that. So always you need to be good at negotiation, and you need to consider options for the client. So considering options is a very important part of the process of taking instructions from a client. When it's your turn to speak and give the client advice, which may be in that first session or it may be later, you need to be prepared to consider all sorts of options. So again, because I teach ADR, we consider a whole wide range of options instead of litigation, or maybe ADR is part of the litigation process. But next week or the week after, we'll do some brainstorming exercises just to see what sort of options might be out there that you can consider in providing holistic advice to clients. Sometimes people want their day in court. Sometimes they don't. Very often they don't when you tell them how much it's going to cost and how risky it is. Sometimes people are hell-bent on having their day in court despite the fact that they should never do that. And that's where you've got to be pretty firm about saying to the clients, for your own good, I really caution you against arguing this case in court just for the principle of the matter. You've got to have a good reason to go into court. Okay, so what I guess we're really saying is share with the client a need to protect their interests or promote their interests rather than necessarily promoting or advancing their simple position. The difference between interest and position is this. It may be your position that you need a pay rise, but it might be in your interest to ensure you have a job. Do you see the difference there? So sometimes you might win the battle, but not the war. And that's some way of looking at difference between interest and position. Okay, so when you're in court, courtroom advocacy, a few things. The first is be prepared, be concise. Often, as we talked about, state your conclusion and then work backwards from there. You know, CIRAC, if you like, if that's the acronym that you choose to use. If you're in court, make sure that you have a copy of cases to which you refer. Often you should have a written submission or a draft order. So if you're going into court asking for an order that the court do this, have the order there ready to go. If you're arguing for a certain position, have something in writing that you can present to the court. Your Honour, I I have arguments based on this fact, but I have written submissions. The court will really appreciate it. You're there to help the court, and if you can provide them with written material, so much the better. So don't rush, be confident, and they're basically the keys in court. If you find yourself asking questions of a witness in court, ask the questions in as simple a manner as possible and avoid double-barreled questions and avoid double negatives. So the red car was travelling fast when you saw it. There's already 3 questions there. Did you see a car? Yes. Was the car red in colour? Yes. Was the car travelling too fast when you saw it? Yes. So avoid double and triple barrel questions, because if they just say yes, you're not sure if they're saying, yes, I saw the car, or yes, I saw it was red, or yes, it was speeding. Okay. Any feedback, any comments so far? Am I doing all right? Yes, David.
I was going to say, in communication, wouldn't there be a certain amount of, I mean, you do have to have some empathy, but you'd also have to have a degree of detachment as well. If you're, say, potentially defending someone who you may not personally agree with whatever it is you're defending, but as your responsibility as a practitioner, you have to adequately represent them.
That's a very good point.
Not to get overly emotional about what you're doing, because you have to still fulfill your responsibility as a legal practitioner. That's
an excellent point. Thank you, David, for raising that point. I should have made that. You're absolutely correct. You do have to have a degree of empathy, but you're not there as a counsellor. You're not trained as a counsellor. Lawyers typically aren't good at being a counsellor, so don't try to become a counsellor. Leave that for the professionals. But you do need to be detached. And part of that detachment, I guess I alluded to before when I said at times you need to be able to say to a client, you don't have a good case. That's my honest opinion. If you want my advice is you don't have a good case. Part of the exercise of reframing, detoxifying that I mentioned before, I guess touches on that as well, David, in that what you are trying to do is strip a statement or a position from the emotion behind it and look at the facts and look at the issues rather than their position. So, really good point. Sarah asks, how much repetition of a particular term is considered more than necessary for emphasis? Yes, emphasis is a really important point. You can repeat it. I think the 3 ways to deal with emphasis are as follows. In a court context, number 1, state your conclusion first and last. That appropriate repetition emphasises the point. The second is pause. If you make a strong point, without necessarily repeating it, you can emphasise it by the pause. And the third is that you can pause before you make the point, so that the court knows something important is coming along. And sometimes you can use your body language for that too. If you're speaking at a regular pace and you're just moving in the same position, if you then stop when you're about to make an important point and perhaps even move in a bit closer, what you're saying to the court is, hey, I've got something to share with you here. Listen very carefully. You don't actually have to raise your voice. You can actually lower your voice to make an important point. And a lot of really good QCs do that. They just lower their voice and everybody sort of strains to listen carefully. I suppose you can do that if you're a QC. But thank you, David. Some really good points there. And thank you, Sarah. Okay, written communication. Oh, I'm sorry, oral communication. Just one thing. Excuse me for saying this, but in the context of any bad habits that you might have, there are 2 things that I don't want to see in your written communication or your oral communication. They're just little irks that I've got. The plural of you is not use. And if you want to know something, you don't ask someone, you ask them. But we still see that. So if you do have those horrible little habits, make sure that you identify them as quickly as you can. Okay. Written communications. Now, I mentioned when you're going to court or you're presenting for an interview with a client, You need to prepare, same thing with your written communication. Plan your thoughts. This group, I would say, are really good in terms of the way in which you present your material. So far, everything I've seen has been great. Use headings, have a professional presentation, be consistent, well referenced, logically written. Use short sentences, understandable content because you're trying to convey the information, not show how clever you are by using large words. So be concise. Write in the active voice rather than the passive voice. What do I mean by that? And I'm talking now oral and written communications. Can someone give me an example of the difference between an active and passive voice?
It's a representation of how words are spoken. The dog bit me, or I was bitten by the dog. The dog bit me is an active. It happened just now. Whereas I was bitten, the dog is passive. Past tense, it doesn't involve someone as such in the conversation as deeply, or presentation or written work, which is why most writing, particularly fiction, is written in the active voice, because they want the readers to keep reading.
Thank you. That's a great summary, Sarah. Did everyone catch that? I think it's very important, and that was an excellent example. And also, when you write in the active voice, generally you can provide more information, and you're not leaving the reader holding their breath, trying to work things out and waiting. You're getting straight to it. So the example I've got is Jim told the tribunal that the victim lost consciousness, as opposed to the tribunal was told by Jim that the victim lost consciousness. You might think that's all very subtle, but it's important. So thank you. Avoid over-capitalising and underlining. Avoid the old-fashioned jargons that you sometimes see. We're seeing a lot of it's going now, but horrible old terms are now being removed from legal writing. Have a look at my sample document if you want to get any idea of the way I think in terms of writing. Avoid cliches, says Sarah. Exactly. Okay. Any questions about written communication? I know that's quick, but the other thing too is have a look at the way in which good writers write their material and learn by osmosis. Any questions? Good. A couple of other things. Try to avoid finishing a sentence with preposition. So what's a preposition? I'm not particularly good at English. I should warn you about that.
A preposition is a statement that has no, like, it's unending, has no concrete conclusion, essentially.
Yeah. An example?
I can't remember the one that my creative writing teacher taught me. It goes something along the lines of the house burnt, or the house was burning as they ran away. It was really, like, I don't use them anymore because I basically had it stripped out of me.
Drilled into you, yes.
But yeah, so, it basically means like an open-ended sentence that it's not a question, but the sentence has no real conclusion.
Okay, so prepositions are words that introduce information to the reader. So examples of preposition are words like in or to or from or for. So what you're looking for is something to follow on from that rather than leaving it at that. So sometimes we talk about prepositional phrases as well. And if you add a prepositional phrase, it will provide better information to the reader. So let's take this example. My client's mother cried, or my client's mother cried with tears of joy. It's just adding that extra prepositional phrase. But the general rule is if you've got a sentence and it ends in or to or from or something along those lines, then try to reframe that, preferably in the active voice. I think you all know that I have an aversion to using abbreviated language. So particularly in your written material, do not put don't. put do not. It's more formal, less conversational, but I think more appropriate. You're all very good at referencing. If you're not good at referencing now, please practice. Have a look at the AGLC, have a look at the information guide at the end, and some of the excellent information guides that have been shared through UCrew. Ah, yes, and so Gay, yep, Gay's got it here. In prepositional words ending with words such as to and for. Thank you. So my personal preference, make sure that when you're typing legislation or case law, you do so in italics, not the whole thing in the case of in the context of a case, but you would for legislation. Now, are we on top of all this? We are, aren't we? Okay, so when you go through to second year, people will say, yes, this group, they've got all the basics right. All right, thank you. I think we're all good with collaboration. We've got an idea of what's collaboration and what's collusion. That's important. So when you're collaborating, you can be in groups and you can plan and you cooperate and you can work with each other. If you are in a group assignment, as a general rule, aim to give more than you receive. And if everyone does that, you'll have a good assignment. Don't be the one that feels that you're receiving more than you're giving. Okay, so just briefly, mediation and ADR. I talked about some of the techniques that we use in that context, but other things to keep in mind. When you're the mediator or the conciliator, I would suggest that you aim to become the participant's new best friend, to borrow from Professor Ashman of QCAT. What do I mean by that? Well, when two parties are in dispute and you're the mediator or the conciliator, what you want is to embed with them a feeling of trust, that they can confide in you, that you understand them. And that will very often happen, and most often happens with both parties. Both look to you in a form of, that they trust you, they listen to you. So if you can become both of them, their new best friend, then you've probably gone a long way to becoming a good mediator or conciliator. You've obviously got to avoid bias, and you've got to think on your feet quickly. So a lot of the skills that you use in mediation or ADR are skills that you use in court. Listen carefully, something will come to mind, and it leads down a path of inquiry that might help the parties to resolve the dispute. Okay. Sarah said, also as a note, CQU offers your tutor service. And I haven't actually, has anyone tried the Your Tutor service? Because I haven't seen what it's like.
I haven't used it, but with my previous degree, I had a similar service called Smart Thinking. And you would submit your work and then indicate what type of feedback you wanted. I typically wanted grammar and syntax feedback because I've always had issues with that. And they would typically provide like general feedback on your assessment and some specific notes, but they would also include notes about grammar and syntax problems they'd noticed that I had and like how the syntax worked with an example. Particularly for me, that was commas breaking up the introduction to a sentence, like firstly, secondly, commas afterwards, like that, and the use of semicolons. If you have a particularly long sentence, but you can't turn it into two sentences.
Thank you.
So I was talking to one of the student support people today for their weekly check-in call, and she was telling me about the service. So I'm planning to try it out with my economic case study, see how it goes.
Okay. Thank you, Sarah. And speaking of commas, I won't go into it. I'll give you some homework to do. Google Oxford comma and how to use them. Can be important in terms of the meaning. And I also take, at least in term 3, statutory interpretation, where we talk about the use of Oxford commas and how that can change the meaning of something. Some homework. All right, so that's a little neat segue into interpretation of the law. We have a full subject on interpretation of the law, statutory interpretation. In your text, The New Lawyer, it's chapter 7, and you'll see that when you're interpreting the law, you need to interpret legislation, case law, and other documents. So there is a body of law that deals with the interpretation of words in a contract, for example, being a private agreement between parties. What you do need to do at this stage is understand that legislation comes into effect at different times. In the Commonwealth legislation sphere, have a look at the Legislation Act 2003 and have a look at the Acts Interpretation Act. Also, be aware that legislative instruments and notifiable instruments come into effect at different times. Have a look at section 12 of the Legislation Act 2003. Now, sometimes, and very often, acts do become subject to amendment, so acts are amended. And what you typically see in OSLE or in the Federal Register of Legislation is the Consolidated Act, which is a compilation of where we have the original act as amended by the publisher. But you can go back and look at previous versions of the act. So if you come across something which is a problem that relates to an event in the past, you may need to look at the act as it was at that time, as opposed to the way in which it is now. It can be important. Now, when it comes to statutory interpretation, there are a few different approaches, but let me start with the most important, the current one, which is the purposive approach. So what I mean by that is that the courts will have regard to the apparent purpose of the legislation. Sally, did you want to say something? Sundari, did you want to say something?
No, sorry, I didn't realise I'd unmuted.
You're right.
Sorry.
Thank you. Now, does anyone have any questions while we're on a little break for a sec? No? All good? All right, so the purposive approach. The court will have regard to the apparent purpose of the legislation. I've mentioned that you need to consider this in the context of the Acts Interpretation Act, both Commonwealth, which is 1901, and State, Queensland, which is 1954. But there are some issues to do with the apparent purpose of the legislation. Can anyone tell me how you would best find, if that's an important thing, and the courts will interpret legislation based on the purposive approach, how can we possibly glean the apparent purpose of the legislation? Where would we look for that? Melissa's got it. James?
Yeah. I was going to say the readings. Isn't it the second reading? Is that where they outline sort of the purpose? Yeah. Mm-hmm. That's the minister. Yeah.
That's right. That's right.
Yeah.
So when the minister introduces legislation, typically it's the second reading that's the important one in terms of what the minister says regarding the legislation. And you can read about what he or she says in Hansard. But to supplement that, Melissa's right, look at the explanatory notes, the parliamentary readings, and there's a whole range of things. We went through that in some detail, didn't we, in legal research. So when you're doing an assignment, you will do much better in the assignment if you can refer back to the explanatory notes, the explanatory memorandum, the parliamentary readings, Hansard, or something to show a depth of knowledge and understanding and researchability. Are we all good with that? Can I pass you on to second year safely knowing that you will do that for me? All right, thank you. even though I'm stressing the purposive approach to statutory interpretation, historically we have the literal approach, the golden rule, the mischief rule. They're less important now than they were originally. So be aware of them, read about them, but if you're going to adopt an approach to statutory interpretation, read with interest and apply the purposive approach. Are we all good with that? You can trust me on that point? All right. There are some common law presumptions and there are some statutory rules that you need to consider as well. Have a look at page 250 of your text and you'll see some examples of common law presumptions. Now, I know you're probably saying it's a bit odd when you're talking about statutory interpretation, which is the interpretation of statutes, to talk about common law, which is judge-made law, but the judges do, of course, create laws through common law which find their way into interpreting statutes. So some of the examples, have a look at number 1. Words have their current meaning. It's a common law presumption in statutory interpretation. An example there is Jones and the Commonwealth from 1965, High Court 112 CLR 206, Jones and the Commonwealth, 1965 112 CLR. In that instance, the court had to consider whether the legislative power to regulate postal, telegraphic, telephonic or other like services incorporated rulemaking for television broadcasting. 1901, they hadn't thought about television broadcasting when they created the Constitution. Number 2, words have their technical meaning. Sometimes words have special legal meaning, and some examples there are legal terms like frustration or provocation. They have particular technical legal meanings. So if legislation talks about frustration in the context of a contract or provocation in the context of a criminal defence, we look to the technical meaning, not what people normally think of as frustration or provocation. Rule 13, things not included are excluded, is a common law presumption, and 15, later provisions override earlier provisions. So a later law is presumed to override, in a sense, automatically repeal to the extent of the inconsistency an earlier law on the same topic. I know that's moving very quickly through common law presumptions, but are we all good with that? All right. Do your reading on that. One hallmark, no, I really must stress this as well. One hallmark of the purposive approach and something that you need to be aware of when you're in court is that a statutory provision must be interpreted within the context of the act in which it appears. It's very dangerous to argue for a particular meaning of a word or a phrase or even a section if you're dealing with that word, phrase or section in isolation, because the court will want to know how that fits within the context of the entire piece of legislation. So have a look at page 243 of your text. There's an excellent example. And if a court is reading a section about students in the University of South Australia Act, it will interpret the word student not as referring literally to any type of student, but in the context of that act, referring to a University of South Australia student. Does that make sense? So you've got to look at the act entirely. You've got to think about the purpose for which it was enacted, and then argue for the interpretation of a word, phrase or section within that overall context. I think we're getting this. Nobody's got any questions? We're all good? All right. I mentioned the Acts Interpretation Act. Have a look at section 15, capital A of the Acts Interpretation Act Commonwealth. And Section 14, capital A, of the Acts Interpretation Act 1954 in Queensland. Those sections really encapsulate the heart of the purposive test. So you've got to know those. And if you want one High Court decision to support any argument based on that, have a look at Mills and Meeking. It's 1990, 169 CLR 214. And pretty much the High Court said the purposive approach has supplanted the literal approach and should be used even if there is no uncertainty or ambiguity. So there's a quote there at page 235 of the judgment in Mills and Meeking. So for the purposes of this course, understand the importance of the purpose for the legislation, know where to look to determine the purpose, have the support of the legislation, the Acts Interpretation Act, Commonwealth and State, and have that one decision, Mills and Meeking, up your sleeve. And that'll do you for this course. Are we all good with that, or have I gone too quickly? Okay. There is figure 7.2 on page 246, where the authors have very neatly provided some material in relation to the approaches adopted for statutory interpretation. So what they say is read the statutory provision literally, determine the context and determine the purpose, kind of mould all those things in. So those sections were Section 15, capital A, of the Acts Interpretation Act, Commonwealth, this is 1901, and Section 14, capital A, of the Acts Interpretation Act, Queensland. Also, be aware that extrinsic materials are often relied upon in the interpretation of an act. What's an extrinsic material? Can anyone give me an example? Appendix, yes. Anything else? We've talked about a few tonight. Explanatory notes, yes. Thanks, Sundari. Yep, explanatory notes. They're coming in now. Hansard, second readings, Sarah, yes, they're all extrinsic materials. Sometimes the parliamentary committees rely upon expert reports. Remember we talked about that during the course of research. They're important extrinsic materials as well. So in the context of the importance of the use of extrinsic materials in interpretation of legislation, Commonwealth, have a look at Section 15, capital A, capital B. That's the Acts Interpretation Act, Section 15, capital A, capital B. That's another one to keep up your sleeve. All right, now you will see also end notes to legislation. Don't just gloss over them. They can be important. So end notes deal with the legislative history, the amendment history, and it gives you, if you like, an account of how each section of the Act has been amended, and it's useful if you need to have a look at past versions. So don't gloss over the end notes. They can be useful. So it'll give you a guide as to what the law was at a particular time. So if you're dealing with a criminal matter, for example, as I mentioned before, you want to know what the law was at the time of the alleged commission of the offence. But the second thing is that the endnotes provide you with a further guide as to why Parliament introduced the amendment. So you can go to the explanatory memorandum in the Commonwealth sphere or the explanatory note in the state sphere to do that. So if we go to, I'm going to give you an exercise to do, and that is go to the Federal Register of Legislation, look at the end notes to the Acts Interpretation Act 1901 itself, and you'll see that Amending Act number 27 of 1984 included section 15 cap A, cap B. So I've said to you tonight, it's important that you understand the way in which you can use extrinsic materials in interpreting legislation. Now I'm saying, all right, let's use our new skills to look at what Parliament said about the introduction of section 15AB when it was introduced in 1984. So do that through the Federal Register of Legislation. Look at the end notes for the Acts Interpretation Act and have a look at Amending Act number 27 of 1984. I haven't got time to go through that in class, so I'll have to trust that you'll do that. Okay. There are, in the context of statutory interpretation, certain key words and phrases that are defined. Always remember to look for a definition. It's probably the most important thing that you can do when it comes to interpreting a word, because if it's actually defined in the Act, that's the important part. So when looking at, oh, thanks, Nicholas. That was quick. So when you're looking at an Act of Parliament, it may be necessary to refer to the relevant act or a word or phrase, and again, have a look at section 13 of the Legislation Act, as I mentioned earlier. Now, the Acts Interpretation Act of 1901 is important for a number of reasons. One of them is that it will often deal with treaties or explanatory memorandum or readings of the bill that we've talked about, and it will provide you with a broad range of information that you need when interpreting legislation. Now, Melissa says, how can gazettes be used in legal research? Anyone have any thoughts on that? How can a gazette be useful? Yes, David?
They can inform you, they won't tell you exactly what's happened, but they can inform you possibly about some amendments or legislation changes that could be occurring. So you can then use that as the first point of information to move on to the second, more important points.
Yep, sure. Very good, thank you. Any other thoughts? Now what is a gazette? That's another research question within itself. So, has anyone subscribed in the Queensland context to the weekly law reports?
Yes, I have.
Weekly Law Reporter. Very good, David, and Melissa has as well. So have you noticed the Gazette information?
Sometimes they give you information about when people are actually going to be admitted as well,
Yes,
I think.
things of that nature, yes.
Yeah.
All right, so gazettes, how do I describe them? They're really like a government legal notice, or like says Melissa, they're really like a government newsletter. And it contains information in the context of legislation about amendments to legislation, and also importantly, dates for commencement of legislation. So often you'll have to refer to the gazettes in that regard. Yes, David?
I was just going to say, in terms of the Queensland Law Reporter, they also let you know about what could be notable cases that have gone through as well. And would that be a case of where they're worth looking out for because they probably or might be or are going to potentially be cited a lot in the future because they do have that kind of relevance? Or
Exactly. Yes. So one of the key aspects of the Law Reporter is that it does report on cases that are likely, in the view of the editors, to become reported decisions in the Queensland reports. So it does take a while before these cases go into the Queensland reports, you'll see the summary in the Queensland Law Reporter almost immediately. So, and again, it's a really good legal research tool. And I like it when I get that coming in the inbox and skim through those case notes. They're excellent. All right. I mentioned that interpretation applies not just in statutes, it also applies in contract interpretation. One drafting technique that you can use if you are the person that wants to convey a particular meaning for a word or a phrase in a contract is to do this. It's pretty common. You put brackets and you repeat the word in the bracket immediately after where it's used the first time. To give an example, if you're in the contract, you're saying something about the Australian consumer law, you might then put in brackets ACL, close brackets. Then, instead of putting Australian consumer law in the balance of the documents, you put ACL. But the way in which the court will interpret that ACL is by looking at how you have described it by giving it a definition. So the court will then say ACL means Australian consumer law in the context of that contract. So it's a pretty useful and common drafting technique. So, but there are some basic rules when it comes to contracts, and one of them is that there is a rule that if a written contract appears to be a complete record of the agreement, then the court will assume that nothing else should be considered in the context of what was agreed. So we call that the parole evidence rule. Basically, it says that if there is something in writing, then it's assumed that all the important aspects of that agreement are incorporated into the written agreement. Have a look at page 260 of your textbook for a list of things that the courts will imply into a contract. And the test, this is a pretty famous phrase, is the objective test, the officious bystander. That's the gentleman, it's always a gentleman in Old English cases, that was sitting on the Clapham omnibus. And what would he think looking at certain events as the officious bystander? What that really means is that an objective test is used, generally speaking. Usually at this stage, and I've run out of time, I like to see you do a redrafting exercise. I'm not sure I'll have time for that, but I used to include that as my exam. So every time you would sit an invigilated exam with me in Introduction to Law, I would physically get you to redraft something, legal gobbledygook, as part of the exam. So time permitting, we might do that, or I might put something up on the on UCrew. And we've just about run out of time. Into plain English, yes, short sentences, understandable, using good drafting techniques to do that. Now, are there any questions, comments? Are we all good? Those of you that haven't submitted your assignment, I guess you want to get back to it. Now, was there a question there?
Yeah, I was just going to have a quick question, John. Let's just say that someone is subjected to a piece of legislation, and then at which point and a result is handed down, like a judgment is handed down against them based on that legislation. Then 2, 3, 4, 5 years go past before they are in a position where they're allowed to go back to court to challenge that judgment. And in that time, the legislation had changed. Where do we start? Do we start our attack based on the original legislation and say now it has changed, so the judgment should be different? Or do we start with the new legislation saying that the old legislation is now overwritten and so the judgment should be different?
I would argue the former of those scenarios. look to the legislation as it was at the time, but give due allowance for the legislation as it is now. Generally speaking, I think that would be the correct approach.
I was reading a murder case in the Queensland Supreme Court about a pretty nasty series of murders that happened, I think, back in 1973, and I was reading the sentencing remarks, and the judge actually kept referring to the legislation or the appropriate penalties for what was happening in 1973, even though the guys were convicted something like 30, 40 years later. It was a very famous Queensland murder case that went through, I think, earlier this year or last year. It was all over the news. And so he was referring even to the legislation of 1973 and when he read out what he thought was the appropriate penalties.
Yes, absolutely. And we see that quite often in terms of things like convictions and sentence for possession of child exploitation material, where over time the penalties, the maximum penalties designated by Parliament have increased, sometimes dramatically, from maximum of 5 years imprisonment to maximum of 10 years imprisonment to maximum 15 years imprisonment. So if you're dealing with one of those historic matters, just to follow on from what Nicholas said, you would apply the law as it was back then. But the court might consider what Parliament has done in the meantime. So thank you, Nicholas. Thank you, David. Any other questions? All right, and some really good material. If you've got a link to something which you've shown up on the screen, feel free to add that into UCrew, and I think we might call it a night tonight. Thank you very much for your attendance. You hang in there very well, and I appreciate it. Okay, all the best, and we'll see you next week. Bye.